We will go ahead and get started. Thank you all for joining us today for this webinar. My name is Dustin Saldarriaga. I'm an associate at Scott Legal PC. Today, we're going to spend some time talking about a very unique and important green card option, the EB-2 National Interest Waiver. And we're going to be doing that in the format of a question and answer session regarding some of the most common questions we get involving the EB-2 National Interest Waiver. A few things before we get started. Some of you may know that our firm was founded on an E-2 visa about 10 years ago. And our founders' experience navigating the immigration system in the United States really does inform how we work with our clients and really is a client-centric approach. Our firm does specialize in business immigration, including the National Interest Waiver. However, we handle the full range of immigration options, whether that's family-based, whether that's humanitarian. So any and all questions we do welcome, and any and all immigration-related cases, please do reach out to us. We will be continuing this webinar, which is part of a series. We try to do at least 2 webinars a month, and these cover a range of immigration topics. Like I said, this is part of that series. And so after this webinar, we will be sending you all a few things. The first is a link where you can sign up for the future webinars. We'll also send you a comprehensive guide on the National Interest Waiver. And we'll also send you in that email a link to our YouTube channel. On our YouTube channel, we post our webinars, and we also post a range of shorter videos on really a variety of topics. So we think it's a really good and important source of free, high-quality information on immigration law in the US. So please do check that out. Today, we're very fortunate to have Jie Huang here with us to speak about the National Interest Waiver. Jie has a vast amount of experience preparing these applications and working with clients and navigating some of the complexities around the visa. So I'm looking forward to hearing her wisdom, and we do thank her for taking the time to be with us. If you all have questions as the presentation goes on, please do use the chat function or the question and answer function on Zoom. I will be monitoring both, and either I'll share those questions with GA in the middle of the session, or I'll save those at the end, depending on where we are in the discussion. But please don't hesitate to send those in. So without further ado, GA, I want to welcome you again. Thank you for spending time with us. And I think a good question to start with maybe is for you to tell us a little bit about why the EB-2 National Interest Waiver is a good visa to know about.
Of course, and thank you so much for the warm welcome, Dustin. The National Interest Waiver is a very attractive immigrant visa category because really you can self-petition, and that is not the case with many different categories. Now, the EB-1 extraordinary ability immigrant visa category, yes, you can self-petition under that as well, but that is only reserved for the very cream of the crop of each field. So the National Interest Waiver EB-2 category is a little broader and more accessible in my opinion. But the advantage of not requiring a labor certification process is that what could normally take 3 years to get an employment-based green card, you can get an approval decision from USCIS in 1 year if you're lucky. And if you can take advantage of the premium processing that will be expanded, you could get a decision as soon as 45 days after filing. So it could be one of the fastest ways one could apply for a green card.
Perfect. And you know, I know we work with a lot of entrepreneurs at our firm, many of them on E-2 treaty visas. Can you talk a little bit about why the National Interest Waiver is especially attractive for entrepreneurs?
Yeah, so in 2016, a case came down called Matter of Danesar, and in that case, the AAO, which is the appeals court for these cases, talks a little bit about why entrepreneurs would normally not be able to be to take advantage of the normal labor certification process because they have ownership over their companies. Now, in recognition of that, the case does discuss the possibility of the NIW being a good vehicle for entrepreneurs who can show that their work has created jobs and will continue to create jobs in the US, especially because the normal process of labor certification does not really apply to them.
Perfect. And you mentioned labor certification. This might be a good opportunity to take a step back. And if you could just walk us through, what are the fundamental requirements for an EB-2 NIW?
Certainly.
National Interest Waiver. We may have been using that acronym. If we say NIW, we're referring to National Interest Waiver. So sorry, Gia, go ahead.
No problem, certainly. So there is a threshold requirement that every applicant must meet, and which is the basic category to meet for the EB-2 classification, which is that someone needs to have an advanced degree defined as a master's or above, or have exceptional ability, right? So once you meet that threshold, then you have to prove evidence of the 3 prongs of a national interest waiver test, which was promulgated by the matter of Danazar case that I was just mentioning. So the first prong is that the work that the foreign national proposes to do in the US should have substantial merit and national importance. And the second requirement is that the foreign national should be well positioned to advance the proposed endeavor, which can be shown by the foreign nationals' experience, expertise, their education, and relevant projects that they have done that relates to what they are planning to do in the US. And the third and last prong for the national interest waiver is that on balance, it should be beneficial to the US to waive the labor certification requirement for that particular individual in consideration of the significant benefits that could come from this person working in the US.
Perfect. I know progressive work experience can be at issue with an NIW application. Can you talk about, if someone has a bachelor's degree, how would they show progressive work experience in order to qualify for the national interest waiver?
Yeah, so the progressive work experience is relevant to meeting the threshold requirement of an advanced degree. So now normally you would have to have a master's degree or above to qualify that you have an advanced degree. But if you have a bachelor's degree and if you have 5 or more years of progressive work experience in your field after you get the bachelor's degree, then you can be deemed to have a master's degree or above. So this is another way you can meet the advanced degree threshold. Now, the 5 years of employment must be in your field and it must be progressive. And what that means is you would typically get an employment confirmation letter from your prior employer describing your duties and how your duties changed over the years. So that letter should describe if your title changed from an associate attorney to a senior attorney, for example, if you're a lawyer, or if you're an engineer, if you were serving as an assistant engineer, but then now you become a supervising engineer. So those kinds of changes show that in those 5 years, you didn't just do the same thing that you used to do on day one, but your duties changed in complexity and maybe your salary changed in complexity. So those are the details that you would want to elicit in those letters that could show the government that, okay, this person really progressed over the 5 years in terms of what work experience they had.
Perfect. And I think one of the very common questions that you receive is, what really is the difference between an EB-2 and an EB-1 visa? And the term that is relevant here is, what is the difference between, how extraordinary ability or exceptional ability is used in the context of an EB-1 versus an EB-2?
Yeah, definitely. Very good question. The exceptional ability criteria. Now, I do want to mention that you don't even need to go into exceptional ability if you already have an advanced degree. And this is something that a lot of people can't quite get their heads around. Some people think that even if you have a master's or even if you have a bachelor's and 5 years of experience, you need to also have exceptional ability. Now, that's not true. You only need to rely on the exceptional ability threshold analysis if you don't have advanced degree, if you don't have a bachelor's, for example, or if you have a bachelor's, but if you don't have the 5 years progressive experience that's required. So the exceptional ability criteria is not the same as the extraordinary ability criteria as per the EB-1A. The extraordinary ability for the EB-1A is a much, much higher standard than the exceptional ability criteria. So the criteria that, so the language that the government will use to evaluate if somebody has exceptional ability as opposed to an extraordinary ability is whether they have a degree of expertise significantly above that ordinarily encountered in the sciences, arts, or business. And there are specific evidentiary criteria that you can look up on the USCIS website, and you need to meet 3 or more of those criteria. And one of them includes 10 years or more experience in a field. Another one is membership in a professional organization in your field. Now, those criteria are different from the EB-1A criteria because, for example, for the EB-1A criteria, there is a criteria that talks about memberships in professional organizations, but for the EB-1A, those organizations must be very prestigious organizations that require extraordinary achievement of their members. Now, the exceptional ability criteria doesn't look that far. As long as it's a professional organization, you can use that experience for the exceptional ability category. So it is worth looking at each criteria in more detail because what they're looking for and whether you can meet a criteria in each category is quite different in a case.
Good. And maybe it's helpful at this point to talk about, obviously, preserving anonymity, but sharing an example of a client or someone you are aware of who's actually met these criteria and what it looks like actually in practice.
Right. A great question. And I think what I'm going to do is I'm going to share a case study that is from one of the appeals cases that came down from the AAO. And now, so for this case, it's a very interesting case, and I encourage everyone to look up this case and read about it. But basically, it is for an entrepreneur, and he or she proposed to set up a small consulting firm. And this consulting firm proposed to conduct projects with philanthropic and government organizations for the purpose of improving veteran services and care for wounded warriors. And this person had a very specific plan. So in the business plan, and we haven't obviously read the business plan, but in the opinion, we can certainly see that this was one of the evidences that they submitted. The proposal was to coordinate organizations and projects to facilitate the reintegration of veterans and wounded warriors to civilian society and help them get their footing to be productive members of society, right? And with this business plan, this person included letters from prospective clients describing how his work would improve currently available program offerings. And these letters were submitted by philanthropic organizations, nonprofits in the field, government organizations, and relevant entities like that. So that, because of that, in those universes of evidences, the government relied on that and ruled that this person's proposed endeavor indeed had substantial merit and national importance. So that's the first prong that we were talking about. Now, for the second prong, is the person well positioned to advance the proposed endeavor? An easy way to think about it is that you could have great plans, but if you don't have relevant experience to really give you the ability or the capacity or the skills to make this happen successfully, then the government could deny your petition, right? So in his case, this entrepreneur, he had very remarkable record of success in past endeavors in his home country, which was the UK. And he received letters of support from senior officials from government agencies who had previously worked with him, right? So he submitted evidence through these expert letters that he had played a leading role in developing and implementing specific initiatives, specific projects to advance wounded warrior care and design new programs to improve service offerings. So for example, and this is one of the examples that the government cited, he made connections between sponsors, philanthropic organizations who could provide financial resources, and service providers, service providing organizations. So he made these connections, which enabled millions of dollars in charitable efforts to be productively connected. And he was the only one who could make that happen because no one else had the breadth of networks and connections and knowledge that he had. So those kinds of examples were cited as reasons why this person was well positioned to advance his proposed endeavor. And I think one last point would be part 3, right? On balance, how is it beneficial to the US to waive the labor certification requirement for this particular entrepreneur? And so one thing to mention is the government would only get to point 3 if they already if the petition already passes point 1 and point 2. Now, when you get to point 3, this person, I would say, had an easier time passing point 3 because he was an entrepreneur. And so the government, in the opinion of the court, discusses that for entrepreneurs, it is impractical to engage in a labor certification process because they have ownership over their companies, because it is a form of self-employment. It makes no sense that they can get a U.S. sponsor to go through that petition for them. Now, and also what was mentioned was the immense value in improving programs and assisting organizations doing this important work that a lot of public interest have been mobilized around it. And of course, his past record of success, which clearly shows that he has unique skills to contribute to this field. So in taking all of these evidences into account, this person was approved for the NIW. And I think this is a great case study for anyone who's thinking of exploring this avenue.
Absolutely. Yeah, I mean, it adds a lot of color to actually understand how someone walked through the process and how they qualified. So that's very helpful. Staying on the topic of entrepreneurs, you mentioned how having plans is oftentimes not enough, that you want to substantiate that, especially when you're showing that you are the best person to do the job.
Definitely.
So when we're talking about someone who's applying as an entrepreneur for an NIW, does it matter if they have an established company or if they have a business concept that they're applying based on?
Right. So in both cases, the NIW could be an option. And now let's break it down a little bit. So if you have an established company, and if you've already had a lot of traction in your home country with that company that you have been managing, you can certainly use that as evidence that could convince the government that you're well positioned to bring in a similar business opportunity to fruition in the United States. Now, if it is a completely new business concept, then you may want to describe how you have gained the relevant experience or expertise in other projects that you've done in other capacities. So for example, if you are an engineer and if you want to set up an engineering firm or a firm to develop a new product and disseminate that product, you may want to speak to maybe your work experience in the past, working as an engineer in that particular field, or if you have authored any patents before on similar devices that you're proposing to develop in the US, you can also submit that as evidence that you have done these R&D work before in the relevant field. So there are a variety of ways you could show that you're well positioned, but if it's just a business plan and nothing else, then it could be a difficult case.
And you touched on this, but are there other pros and cons in terms of applying with an established company versus a startup?
Yeah, so if you already have an established company, right? And so the pros would be if you already have revenues that you have been reaping, and if you already have a good number of employees that you have hired, that definitely shows that you have the wherewithal, that you have the capacity to bring in further economic growth, and that could support your case. And also another advantage of someone who already has business experience is if you have had, if you had led projects with high profile entities, for example, if there were high dollar value contracts, for example, that you can show that the degree of the work that you have been doing in the industry has been recognized to such an extent that could lead the government to think, okay, if this person continues this work in the US, the impacts will be big. So that could be a pro. Now, a con would be if you have a company that has not been doing so well, then it could be a little bit of a stretch to say, okay, for 5 years, I've had this amount of growth, but I'm projecting this amount of growth in the future. Now, that could not be very persuasive just because you have been doing the same thing. But if your hiring numbers or if your revenue numbers have stayed at the very low levels, then it could not make a very persuasive case.
That makes a lot of sense. And when you're working with someone who is applying based on a startup,
right,
what kind of evidence do you include in that application? And how do you think about how to convince the government that this is a business that will succeed? And do you need to convince the government that this is a business that will succeed?
So one thing to note is that you don't need to convince them that the business will eventually succeed, because the government recognizes that, the nature of startup endeavors is that, to a certain degree, there is risk. So the government is not asking you to prove more than 50% or a preponderance of the evidence that the endeavor would ultimately be successful. Mm-hmm. Now, what I do think you need, though, is a credible and detailed plan of what you're going to be doing and some support behind a more broader industry level impact that your work will have. So, for example, if you propose that you will provide good services to your immediate clients, which could be a modest number, or which could be consistent with what the industry is currently offering, then it would not be a great case for an NIW, because what the NIW is looking for is a business that will bring some sort of innovation to change the envelope of how things are being done in the field as a whole, or if a business will develop a new product that will improve how the existing technology is in a material way. So what I would do to really convince the broader industry level impact of the government is to really ask the client to provide details of what has been done so far to develop this product. What is the research that you've done, comparing this technology to other available technologies in the industry, and really develop this detail through the expert letters from industry senior officials in the industry who could confirm that this idea really has traction.
Perfect. And it really is an opportunity to kind of advocate for yourself as an applicant,
yeah.
Not the time to be humble. It's the time to brag and think about anyone along your career path who can put in a good word and say, this is the person for the job.
Definitely.
So while we're on the topic of evidence, how long does it take usually for an applicant to pull all this evidence together for an NIW?
A very good question. So I would say it would take at least 90 days on average if you focus on it, and for you to really pull all the evidence and work on drafting or working with the expert to draft expert letters to the right level of detail that would make it compelling for the petition. I think 90 days is the shortest period of time that I've ever taken a case from inception to submission, and many clients do this on and off matter, I've been finding, because they're also running their own company. They tend to be busy, and there is a lot of drafting and writing to be done. So, and I think in this case, this can elongate the timeline. So I've seen clients work on it for months, 6 months, and maybe up to a year before submitting, if they're not in a rush.
And so one way that I'm sure people are curious if they can shorten the amount of time it takes them to prepare the documents is to use documents that already exist, such as recommendation letters. So is that allowed by the government to use old recommendation letters from, say, previous visa applications?
There is nothing that prevents an applicant from using an old letter from that they have already used for a different category. It could be a little awkward if it says, oh, this letter is in support of O1 visa and it's an NIW petition, but technically it's not prohibited at all. I would recommend, though, to prepare a new letter specifically for the NIW, because the focus of what we're trying to prove in the NIW may be different from, for example, an O1 letter. So just to have the O1 visa as an example, the focus of an O1 is on the applicant himself or herself, and how famous is she or him. What has she done that has, given her or him prestige in the field? So the focus is really on the individual, whereas for the NIW, what is really important is what is the impact of what you're going to do in the US. So in that way, if there is no discussion about that, then that letter could not be as effective as a letter that you could write de novo, in which you can include those details that could make the petition more compelling.
Perfect. I'm going to pause real quick and just encourage anyone who's watching, feel free to send in questions. We haven't received any so far, so if there's anything that's on your minds, please do feel free to send those in. And again, use either the chat function or the Q&A box on Zoom. So GA, following up on this, can you say a little bit more about what should be in the expert letters that are submitted with an application?
Very good question. Again, in a lot of the cases, the expert letter preparation process takes the most time, and for good reason, because the expert letters really flesh out what the applicant's plan is and what the applicant has done in the past to persuade the USCIS officer of the merits of their project, because it is a little difficult. If you look at the business plan, it could be 30 pages. You need to flip to really understand what the person is doing and how that improves things are done in the field. But an expert letter could really spell that out in terms that make it easy for the officer to understand, right? So I would say a good expert letter should have 3 elements. And so the first element is the expert should talk about their own credentials and why the government should trust the expert's opinions on the merits of the applicant's work. So usually we include a full CV, a curriculum vitae resume of the recommender. And they usually tend to be senior officers in top tier companies, or professors in a field with many years of experience. And if we're getting support for an entrepreneur, for example, someone who has that level of high level executive experience. So after discussing their own credentials, the second element that we want the letter to cover is a couple of examples of some successful projects that the applicant has done in the past that is related to what the applicant is saying he or she will do in the US. So for example, if we're talking about an entrepreneur who is planning to set up a consulting company to advise somebody on sustainable building practices, let's say, then we will want to elicit examples of 2 to 3 projects that they've done in the past where his or her work resulted in improvement of protocol in some way, which ultimately did make the project more sustainable than it would have been without his work. So I hope that makes sense. And it is very important to have concrete examples of this, because the government will be more comfortable approving your case if they have a good idea of what level of impact this person's work had in the past. So it is a little difficult to just approve in a vacuum if they can't paint a picture of what this person's work has resulted in the past. So results and impacts are two very important things that you should think about when exploring the content for your expert letter. Now, the third and last content that I would recommend somebody to put in their expert letters is an explanation of why this person's work has national importance. And this is one of the most important points that you can make, because it makes the link between the person's specific business and how it can help advance causes of national importance. For example, for the consulting entrepreneur we've talked about in the veterans industry, right? So the expert letters made the link. Okay, we did not previously have links between the philanthropy organizations and service providers in the past, but this person can come in and make those connections, which could result in more $100 millions being put into good use. So you have that link, right? There is a gap, and then your work is going to fill this gap, and this is why this is going to impact the industry to a better place. Something like that.
Perfect. No, that's extremely
Hopefully it
helpful.
helps. Yeah.
Yeah, I think it absolutely does. And so if you were sitting, if instead of being your colleague, I were an entrepreneur who's building a business, and I'm thinking about applying for an NIW, maybe a few months or maybe a year down the road,
Sure.
what would you tell me are the key things I can do in that time to really prepare to have a strong NIW application?
Right. So I would say start gathering evidence of how your work benefits not only your immediate clients, but advances best practices in the field as a whole. So I'll ask you things like, what do you do differently than other practitioners in the field? And have you shared those kinds of advanced knowledge and know-how with other experts? Have you written any research articles about, your methodologies in your field? Have you authored any patents that have been published? Have you ever presented as a speaker at an industry conference, for example? Sorry. Talking about your insights and your specific know-how. Have you appeared in any media interviews, or if you had any articles written about you and your work? All of these things could help constitute the universe of evidence that the government is looking for when they're trying to find, okay, how do we know that this person will advance the industry as a whole, as opposed to just benefiting their clients? And another helpful point of evidence is, have you participated in any government-funded projects? And because this category is the National Interest Waiver, if a government agency is involved in your work, of course, it's going to be a huge leg up in your petition. So I would advise you to work on those things.
It's inspiring to hear the list, and I think it reminds me how impressive many of our clients and the people who apply for this visa are.
They really are, yeah.
I actually know of one immigration lawyer in particular who actually looked at these criteria, and she's a U.S. citizen, but she said, you know what, I want to aspire to these things in my practice. And so she actually puts herself out there in terms of publishing, in terms of having media appearances. And she's like, I want to be, exceptional as an attorney in the same way that my attorneys are. And so, it really is a quite amazing set of, things that people can do that you've laid out to really position themselves well for this. Now, let's switch gears a little bit and talk a little about the practical side of applying for this visa, an EB-2 NIW. Can you say a little bit about what the timeline is? Maybe start with, you've been working with a client, you said, it takes usually at a minimum about 3 months to pull together all of the documents. So let's say you've done that, the application's ready to file. What happens then? How long does it take? I guess first, like, what is the process? Where does the application go? And then how long does it take at each step of the process?
Very good question. So the first step of the NIW petition will be filing the I-140, which is the immigrant petition for foreign worker. And you file that directly with USCIS. Now, without premium processing, I've seen it takes on average approximately 1 year to get a result. Right. I've seen clients get a result in 10 months, 11 months, and sometimes shorter, actually. But usually it takes about a year. with premium processing, which is currently available to petitions filed before February 2022. And so if they already filed it, they can upgrade, right? So they can get a result in 45 days. Now, a result means either an approval or an RFE or an NOID, right? An RFE means request for evidence. It means the government wants you to bolster some aspect of your petition. NOID is similar to that, but the government is a little less, a little more hesitant to approve your case. They're leaning towards denying it and giving you a chance to respond. So any of these three things can happen within the promised period of 45 days. Now, either after the year has passed or after 45 days has passed, the second step is the actual application for the green card. Now, you can do this in two ways. You can apply through a consulate in a foreign country and get an immigrant visa after an interview, and then come into the US with that immigrant visa and get the green card after that. Or you could, if you're already in the US in a non-immigrant status, you could apply to what is called an I-485 adjustment of status application. And with that, you can change your status within the US to a green card permanent resident, green card holder, permanent resident. And processing times vary quite widely for the I-485 I've been seeing. I have one case for somebody in Maryland, and in the Maryland service, one of the Maryland service centers, it's been taking more than 30 months, which is quite nuts. and bear in mind that you can apply for an employment authorization card based on the I-485 so that you can continue working while your I-485 is pending. So that can be a little bit of a relief, because usually the employment authorization card comes down quicker than the I-485 being approved. But again, this also depends on case by case. So
absolutely. And so when you mentioned the three ways that USCIS can respond, if you choose premium processing, and let's say you get an NOID, notice of intent to deny, once you respond to that, you are still on the fast track, right? So
yes,
once
you
you
are,
give them the documents, they're supposed to get back to you within the shorter time
days.
period.
Definitely.
Exactly. So
yeah.
Now let me ask you, so you mentioned once you file the I-485, which is the second part of the process you described, you can file an application for a work permit as well as travel authorization, right? So once you file the I-140, once you take the first step, is there anything that, let's say you don't choose premium processing, you opt for the 1-year option, how do people fill that time? Can they work? Can they travel? What happens during that period?
Right. So it is very important to note that filing the I-140 on its own does not provide any status in the US on its own. So you should maintain your current status or extend your current status if it is expiring to fill that gap. And if you run out of that status, you can also leave the US, wait for the I-140 to get approved, and then you can apply for consular processing from your home country and get the immigrant visa before returning to the US. And so, yeah, it is very important to note that in order to benefit from this, employment authorization, travel authorization, and extended status in the US while your application is pending, you need to also file the I-485, the adjustment of status. If you just filed the standalone I-140, that in itself will not extend your current status.
Perfect. And you do need to wait for the I-140 to be decided before you file the I-485?
No, you can, in some cases you can file concurrently. So you can, when you file the I-140, you can file the I-485 together. And that's if, the visa bulletin, you can check the visa bulletin, and if for your country of origin in your category, if the number is current, then yes, you can file the I-485 concurrently with the I-140. And many of my clients actually do that.
Perfect. And so tell me about family members. Let's say you're married, you have a spouse, and you have a child. What are the benefits they can receive if the principal is applied for an NIW?
Yeah, so spouses dependent children under 21 years and unmarried can join your petition and also receive a green card.
Perfect, perfect. Well, GA, I think we have actually run through the questions, the key questions I wanted to ask you. Again, if anyone
Perfect.
who's participating has additional questions, we do have a bit more time, so feel free to send those in either through the chat or the question and answer function of Zoom. GA, I guess in the meantime, while any questions roll in, is there anything else that you think is important for someone considering an NIW to know? What would you want them to know?
That is a very interesting question. I haven't thought about that before. If I could say one thing to a potential NIW applicant.
Something you haven't already shared, because you've already shared a lot about what they should know.
Yeah, I would say the NIW is a very advocacy heavy petition. And even if you have the same facts, if a different lawyer prepares your petition and presentation in a different way, it could change how things go. And you could have a weaker case, but you could work with someone who really advocates for you, or if you get expert letters that really advocate for you, and maybe you can, tip it over the edge. So it really depends on individual's risk profile. Like if that person is, for example, not in the US right now and wants to come in for it, you can certainly, try filing. And if you get approved, you can apply for an immigrant visa. If not, you can certainly apply again. There is nothing that prevents you from applying again. So I would say definitely consult with an attorney if that's within your dreams. There are many ways to strengthen a case for the NIW, and a lot of it depends on how you present your plans and how you conceptualize your plans. So definitely be creative. And think about in what ways can you offer advancements to the economy, to the society, to a particular field. Yeah.
And G, actually, in you saying that last part, you reminded me of one common question that I've heard come up, which is, we're talking about a national interest waiver.
Right.
Is it necessary to show that your impact is national, that you're affecting Seattle, Washington, as well as Miami, Florida, and New York City, you've got the whole country covered? Or is it okay to say, I'm benefiting my town, I'm benefiting my city, my community? How do you approach that?
Oh, that is a very, very good question, because that's one of the things that changed after Matter of Danazar, the case that came down in 2016. Before that, one of the criteria was your endeavor should be national in scope, which means geographically your work should affect everyone in the US, like Seattle, New York, California. Now with the new criterias, you don't have to show that this wide geographical scope. Let's say you are building a factory in Arizona, and let's say the particular community that you will be building a factory in Arizona is a traditionally underprivileged community with lots of unemployment figures rising. So if you say that you will be creating jobs in that particular community, which is designated as one of the targeted employment areas, for example, that could be a very compelling case, even if the factory is only in Arizona and you don't have any other geographical satellites of your company. Even if you just operate your company in Arizona, that could work. So it really depends on the facts.
Perfect. And I guess the flip side of that question is, when someone approaches you and they say, I have a business, maybe I've been operating it on an E-2 visa. It is, just to take a hypothetical, it is it's a laundromat, and it's located in New York City, and we employ 3 people, and I want to apply for an NIW because I employ 3 people. I provide employment opportunities. Do you think something like that would be sufficient for an NIW?
I would say it would be very difficult for a petition without more to get approved for an NIW for that, because as you said, the relevant wording is national importance, right? And how could we argue that one laundromat hiring 3 people the impact of that economic activity could rise to a nationally important level. Now it'll be very, very hard.
So basically, there's a scope here.
Exactly.
And like what we just described might not be sufficient, but you also don't need a business that is affecting the entire country. And depending on the community where the business is, if it is economically depressed, for example, suffering from high unemployment, you may be able to make the argument, but it really needs to be more than just a business that employs people. You need, again, to advocate for yourself, right?
Exactly. A lot of work will be needed to that.
Yeah. Well, GA, thank you. No additional questions have rolled in yet. So I'll just first of all, thank you, GA, for sharing your wisdom and your experience with us. I think you've shared some great tips, and just it's helpful to illuminate the requirements and kind of map on your real experience onto what you can read are the requirements. It helps a lot. For all of you who are participating and listening in, we will again be following up with an email, so keep an eye out for that. And we do hope to see you on our future webinars. So please do join us in the future. GA, thank you again.
Thank you, Dustin. Thank you, everybody.